Hello, my name is Glyn Morgan, and this is an introductory lecture to the online class Philosophy of Law, Philosophy, Political Science 375. Now, I know that a number of you are taking this class online from a distance from Syracuse. Some of you may be on a Coast Guard ship off the coast of Florida. Some of you may be in the mountains of the European Alps. I know that you are not all here. So this class is designed for people who are a far-flung audience. And I further am aware that many of you have full-time jobs and are doing this class in the evening after a full day's work. And I have designed this class to accommodate your needs. There are a couple of you who are Syracuse undergraduate students, and I've warned you that this class is really not designed for you. It's designed for the people of the College of Professional Studies, but you are also welcome to attend insofar as you realize that this is not your typical undergraduate class. Anyway, I just want to introduce the class in general terms, what we will be doing for the next 8 weeks, and then I will focus specifically on what we will be doing for this week. So, Philosophy of Law is a class that looks at the law in general and asks fundamental questions about the nature of the law. What is it to order a society by legal means rather than by violence or by custom or by morality? Law is a distinctive way of organizing a complex society, and organizing a society by law has certain advantages and disadvantages. So this is a class that is pitched at the general level. Another way of putting it, it's pitched at the philosophical level, but it also has applications to specific features of the law as we understand it today. And we will be looking at a number of hard cases, difficult problems, current legal controversies. I've organized the class into 8 different topics. We begin in the first week with the topic of what is law. It's a very general introductory lecture, and we will be focusing on the historical dimensions of law, how legal codes have changed over the last 2,000 years. And then we go on to, in our second week, a central topic in the philosophy of law, and that's the topic of natural law versus legal positivism. Natural law refers to the idea that for a law to be a law, it has to have some rational or natural or good or even godly backing. And some people argue that insofar as a law lacks that backing, it's not a law. The other position, which I think is the mainstream position for most contemporary thinkers, is that a law is a law merely when it is enacted by a sovereign state, and it doesn't need a backing beyond the command of a sovereign state. And that latter modern view is called legal positivism. Now, of course, the legal positivist then runs into problems when we have cases of fairly obviously immoral laws, such as the Fugitive Slave Act of the 19th century in America, or the laws concerning Jews in Nazi Germany. And we will be addressing those topics in week 2, and also in week 3, when we look specifically about the rule of law in Nazi Germany and the rule of law in slave societies. That will take us to week 3. Week 4, we look at the question of why obey the law. That's a question that is given the name The Nature of Legal or Political Obligation. And we will look at that through historical figures like Socrates. We will also look at Martin Luther King's letter from Birmingham jail. Week 5, we take up the question of liberty and the limits of law. Under what circumstances does the law have to give way to individual freedom? And we will take up that topic again in week 6 with reference to freedom of expression. Can the law ever legitimately restrict speech? And that's a topic which is a very hot, controversial issue today around terrorism and around racism and around hate speech. Week 7, we look at the topics of crime and punishment and examine in particular the question of whether the United States relies too heavily on punitive measures and imprisons too many people. Question 8, our final question, concerns democracy and the Supreme Court. The United States is quite distinctive in having a Supreme Court that can override majority decisions made by Congress. In other countries, their courts are more restricted, and we need to examine the pros and cons of having a Supreme Court. Okay, on to the topic of week 1. I want to introduce the major themes and talk a little bit about the readings that we will be doing this week. So the question that we're addressing is, what is law? And I've got a variety of different perspectives on that question that come from historical documents, and I'd like you to read a variety of different historical documents just to get a sense of how legal codes have changed. So I'd like you to begin with a document which is actually one of the oldest recorded legal codes. It's known as the Hammurabi Code, and it comes from roughly 1750 BCE from Babylon, and it's a code of law that was recorded on a statue or tablet, and that statue or tablet was only really discovered in 1900 and by archaeologists who then were able to understand a little bit about how law worked back in 1750 BCE, which is, nearly 4,000 years ago, in Babylon. And if you read it, it's a pretty weird document, and it lays down quite in a detailed fashion what this society deemed to be a crime, what punishments were to be inflicted on the people who committed the crime. And one of the things that I'd like you to ask yourself as you read this is, in what way is this document different from a legal code today? And what are the similarities and differences? And one of the things that will immediately leap out at you is that this society of Babylon, 1750 BCE, was not a society of equals. Not all people were equal under the law. This was a society that consisted of slaves and free persons. Within the category of free persons, you had wealthy people and poorer people. And then you had the king. And you'll read through this Hammurabi Code and you'll see that the punishments were different depending upon your status in society. And so let's begin there. Read it, and at our first meeting, I'd like to talk about some of the similarities and differences. That's reading number one. Reading number two moves forward historically a little bit to the Roman Empire. And we're talking about Roman law, or Justinian law, as it's sometimes referred to. And we see similarities with the Hammurabi Code. This is clearly not a society of complete equals in the way that ours is, but there are also some differences. And Roman law is interesting because it then forms the basis of a legal tradition. You get in the Roman Empire for the first time the science of jurisprudence. People identify principles of law. They begin to think about the philosophical issues of punishment and crime and what the purpose of law is. And in a sense, the philosophy of law emerges out of the reflections of the jurisprudential thinkers of the Roman Empire. And it isn't just that it's philosophically interested. Roman law becomes the basis of law for much of continental Europe. And it is interesting to think about this as the foundational text of European law. The third document I'd like you to read leaps forward another 1,000 years in history to a certain extent, and that's the laws of King Alfred of England. We're talking about the 10th century, 9th or 10th century, in the Christian era. And there you'll see similarities and differences with the Hammurabi Code. I'm not going to define it for you, but look very carefully at this word, Wergild. Look it up. What did it mean? Wergild, W-E-R-G-I-L-D. It seems to be central to this society, and it seems to enter into law. Next up, I'd like you to, going forward again in history, we're going to look at the Act of Uniformity, which took place, which was enacted by Elizabeth of England, Elizabeth I, who ruled in the second half of the 16th century. This is interesting to us because for a couple of reasons. One, this is where medieval Europe as a Christian entity begins to break down, because you get divisions between the Protestants and the Catholics. And the Act of Uniformity was an effort to identify a legal basis of order when you have fundamental disagreements in society. That's one reason why it's interesting. The second reason why it's interesting is because you'll see that the law of England was very committed to maintain the Christian faith and would penalize people who didn't worship in the right way. And that becomes really a position that liberals in the 17th and 18th century, and even liberals down to the present day, take issue with. They don't think it is the task of the state to preserve the Christian religion. They don't think it's the task of the state to enforce a particular understanding of the Bible. And so I really want to look quite closely at Elizabeth I's Act of Uniformity. And then I've got a short reading on the rule of law in England and the rule of law in Tudor England. Can we say that Tudor England had the rule of law? And this is interesting philosophically, because this concept of the rule of law will figure quite prominently in this in this class throughout the semester. What does it mean for a society to have the rule of law? One understanding of this term, the rule of law, is a society which respects basic procedural fairness, so that decisions are not arbitrary. Decisions are procedurally fair. And one can look at a society and say, is this a society which has procedurally fair adjudicative mechanisms? And the second way of thinking about the rule of law is that the rule of law requires a legal system that treats all people as equals. All individuals count as one, whether you're rich or you're poor, whether you worship religious X or religious Y, you all count as equal under the law. If you adopt that second understanding of the rule of law, then I don't think that the Hammurabi Code or the laws of King Alfred can be counted as consistent with the rule of law. What about the rules of Tudor England? I'll leave that up to you. It's something we will discuss at our first meeting. And then the last thing I'd like you to do, it's a bit of a curveball. I'd like you to read a very famous case. We're leaping forward again into the late 19th century. It's the case of Regina, which is a word for the Queen, or Rex is the King. All court cases concerning major crimes in England begin with the word R. In America, it would begin with the People versus. In Britain, it's the R versus. And Dudley and Stevens. Dudley and Stevens were two sailors who ate someone and were prosecuted for murder or manslaughter. And the question I want you to consider is, do you agree with the judge's decision to find Mr. Dudley and Mr. Stevens guilty of murder? That will be your readings for the first week. One last point is concerning the videos. This is, I think, the 5th year I've taught this class, and I'm recording a new introductory lecture because I've changed the readings a little bit. But there are some older lectures which I recorded when we were reading Bentham and Hart, which I think are completely relevant to our current topics. But I don't want you to read Bentham and Hart anymore. I think it's too demanding. So I'm going to leave Bentham and Hart on the reading list as recommended readings if you want to go into them, but you don't need to. So there are 3 introductory lectures today for this week. One's called Introductory Lecture, and the other 2 are called Instructor Lecture 1, Instructor Lecture 2. And I think you'll figure it out. So that's what we are doing. In our first meeting, I will go over the requirements. You have various quizzes. You have various short writings to do. You can possibly write a paper. I'll go over all that boring bureaucratic crap on our first meeting. I look forward to seeing you. Before class begins, I would be very grateful if you would post a photo and a bio on the Blackboard, and that would help me remember you. And I've posted one of my own, so you will know something about me. Over and out.